Hello and welcome. I'm Peter Afrasiabi. I'm a partner at One LLP in Newport Beach, California. And today's ethics program is about our wild and crazy judges. We're going to be looking at the ethics lines that get crossed by judges in certain circumstances. Now, before we dive into this, I wanted to talk to you briefly about our Curious Lawyer programs and their purpose. They allow us to intersect with different areas of the law and society and look at different issues, perhaps through a different prism to the normal continuing education that you do. So, for example, as you see here, we've done CIA law, we've done presidential pardon law, we've looked at celebrity and paparazzi law, sex, drugs, and rock and roll, which has allowed us to look at issues related to laws surrounding drug use, sale of medical marijuana, music, rock and roll, sex, lifestyle industries, and intersect them with contract, tort, and other areas of law. We've also done a Bill of Rights series, and so in that series you can spend an hour on each of the first 10 amendments to the Constitution. You'll know them all, and we've even looked at Yellowstone and whether there happens to be a perfect murder zone. To answer that question as to whether you could actually commit a crime and get away with it because there is a lawless, jurisdiction-free zone in America, you got to watch the program. Now, for today, however, we will be looking at some of these topics related to ethics and judges and some judges gone wild. And so we're going to be looking at, from our beginning, the ethics rules and the governing principles and rules that control judicial impartiality, judicial candor, the duties of judges. We will then look at cases from around the country, cases of judicial impropriety and situations where ethics lines have been crossed by judges. We will look at the nature of punishments for these ethics transgressions by our judges. And as we will see, the punishments vary from being incredibly light and mild to sometimes serious. Along the way, we're going to look at a lot of fun, interesting, exciting cases for you. We're going to look at the case of the judge who searched a party's home and seized property. Yes, I know you heard me say that and you said that can't be true, but it's true. The judge got off the bench and went to someone's home to search it. We're going to look at the judge who handcuffed the defendant's teenage daughter in court. We're going to look at the judge who made race-based comments. We're going to look at a judge who even had sex in his chambers with former interns and practicing lawyers. We're going to look at the case of the judge who jailed a woman for a year for unpaid parking tickets. The case of the judge who jailed a spectator in court for, believe it or not, dropping sunflower seeds. Don't take sunflower seeds to court, apparently. We're also going to look at the case of the judge who went on vacation with the prosecutor right at the end of the trial, little family trip after the jury came back. We're going to look at whether that's okay. And of course, we're going to look at the judge who took bribes to find not guilty verdicts. This will take us back in time a little bit. And then we're going to look at the case of 3 judges who together, they couldn't get into a strip club, so they ended up going to White Castle to get some burgers. They ended up in a brawl where, believe it or not, 2 of our judges got shot. Not by the 3rd judge. And finally, we're going to look at the case of the judge, the public defenders, and the hot tub. So let's get going. We're going to start by looking at this picture you can see here of a man named Judge Landis. Now, we're going to start framing the ethics questions by going back to the early 20th century. And this was a federal district judge in Chicago, District Judge Landis. And District Judge Landis was a big baseball fan, so he decided, I'm going to take a night job. And his night job? Baseball Commissioner Landis. So, federal judges, look, they only got paid about $7,500 back then. The baseball commissioner job was a $42,000 salary. He wanted both of them. So he refused to step down from the bench, and he just did both jobs, took both salaries. Now, at this time in the early 20th century, there were no ethics or bar rules to control his behavior, to delimit what he could and could not do. And the only mechanism basically to address Judge Landis was congressional impeachment, and a impeachment effort, along with a sort of issued censure by the ABA. He went before the House, and the House said, What is to prevent baseball owners from going into the Supreme Court now and hiring every member of the bench? I think it affects the very soul of this government. This was during hearings, and that was Representative Benjamin Welty from Ohio at a House Judiciary Committee hearing in 1921. And so this became a big brouhaha in terms of the risk to judicial independence. The Attorney General at the time, however, said, look, Judge Landis is within his rights. There is no bridling principle at play out there to control or delimit his right to do this. So nonetheless, there was a lot of political pressure, and so he resigned after 14 months of doing both jobs. Now, that resignation ultimately led to the first set of judicial ethics codes. Don't forget Judge Landis, because we're going to come back to him in a little while. So let's take a look here at the Federal Judicial Ethics Code. And you can see on our slide here, we have all of Canon 2 and Canon 2A reproduced for you. Canon 2 and 2A are very important canons. We'll come back to them, but basically it involves the principle that a judge should avoid impropriety and the appearance of impropriety in all activities. A judge has to respect the law and act in a manner that promotes public confidence in the integrity and impartiality of the judiciary. Outside influence. A judge should not allow family, social, political, financial, or other relationships to affect his or her conduct or judgment. They shouldn't lend the prestige of the judicial office to advance the private interests of the judge or others, nor convey or permit others to convey the impression that they are in a special position of influence with the judge. Now, all of these different aspects of Canon 2, we're going to see them running through all the fun cases today when we look at Judges Gone Wild. A judge should not hold membership in any organization that practices invidious discrimination on the basis of race, sex, religion, or national origin. Now, 2A focuses on an appearance of impropriety, and this occurs when reasonable minds with knowledge of all the relevant circumstances disclosed by reasonable inquiry would conclude that the judge's honesty, integrity, impartiality, temperament, or fitness to serve as a judge is impaired. Public confidence in the judiciary is eroded by irresponsible or improper conduct by judges, including harassment and other inappropriate workplace behavior. We'll be coming to that too. So basically, a judge must expect to be the subject of constant public scrutiny and accept freely and willingly restrictions that might be viewed as burdensome, for example, by you, by me, the ordinary citizen, in terms of our First Amendment rights, our right to engage in certain speech, conduct, activities, participate in social events, right, political events. Judges are bridled because of these important canons that we will come back to. Now, there's also another overview here, and that is the Federal Ethics in Government Act. And as you can see on our slide here, judges are required to file disclosure statements that list financial entanglements, holdings, issues of money basically, or ownership interests in stocks and bonds and the like, things that could trigger the need to recuse. Now, these are disclosure statements that are filed by our federal judges. They're actually public. You can go find them somewhere online. But there is no review process in practice for accuracy. So it's sort of, it's up to the judge to identify and list the different things that judge owns or doesn't own. Now, lower judges can be challenged, and judges, either they're judges on the bench or higher judges, can address the charge. But these canon codes also are not 100% directly applicable to the Supreme Court. The Supreme Court actually doesn't have anyone empowered to review it. In other words, there is no binding law that exists as passed by Congress, for example, that forces a mechanism on the Supreme Court to subject itself to review, and if so, who reviews it? It's a self-reporting mechanism that doesn't really have a real basis to challenge. Now, one of the issues we'll look at as we're still framing our ethics rules is 28 U.S.C. section 455. And big picture, I could pause here and mention to you, we're looking primarily at the federal ethics canons that govern these structures, but the state codes are all very, very similar, with maybe small word variations, but the canons are basically the same. And we'll see as we walk through some of our cases coming out of state court shortly, you'll see the same basic canons at play. But we're using the federal overlay to walk through this for this program because it's got nationwide applicability for all of you around the country. So what is 28 U.S.C. section 455? On this slide, you can see this is the governing statute that deals with the ethics questions of disqualification and when a judge must disqualify him or herself from a proceeding because impartiality could reasonably be questioned. And 28 U.S.C. section 455 lists a few circumstances where this should happen. For example, if the judge has a personal bias or prejudice concerning a party, personal knowledge of disputed evidentiary facts. Number two, if in private practice the judge served as a lawyer in the matter or controversy at issue, or a lawyer with whom the judge previously practiced law served during such association as a lawyer concerning the matter, or the judge or such lawyer has been a material witness concerning it. Number three, if the judge has served in governmental employment and in such capacity participated as counsel, advisor, witness concerning the proceeding at issue or expressed an opinion concerning the merits of a particular case or controversy. We'll be looking at a case shortly of a judge who did express an opinion concerning the merits of a particular case or controversy that ended up being before the judge. Perhaps the judge knows that he individually or as a fiduciary or a spouse or minor child residing in his house has a financial interest in the subject matter in the controversy. For example, situations where you own a bunch of stock in Microsoft or something and Microsoft is before you in the court and it could be, destroyed or bankrupted or whatnot. That's the type of issue that number 4 is talking about. And also, finally, number 5, if the judge or the judge's spouse or a person within the third degree of a relationship to either the spouse or the judge is a party to the proceeding, acting as a lawyer in the proceeding, is known by the judge to have an interest that could be substantially affected by the outcome of the proceeding, in those types of situations where impartiality might reasonably be questioned, the judge needs to recuse. And if the judge doesn't, it triggers these ethics violations that we will be looking at. So before we get going, let's just quickly walk through the overarching canons. And we looked briefly at Canon 2, which is really our principal one that tends to animate most of the conversations. But let's start with Canon 1. An independent and honorable judiciary is indispensable to justice in our society. A judge should maintain and enforce high standards of conduct and should personally observe those standards so that the integrity and independence of the judiciary may be preserved. Canon number 2, two little quotes from Canon 2 here, 2A actually, that we looked at already, but these are the ones to keep in mind. Judge must act at all times in a manner that promotes public confidence in the integrity and impartiality of the judiciary and must avoid impropriety and the appearance of impropriety in all activities. As we move to the next slide, let's take a look here at Canon 3. And this involves the duties of the judicial office take precedence over all other activities. The judge must perform those duties with respect for others and should not engage in behavior that's harassing, abusive, prejudicial, biased. So for example, judge should be faithful to and maintain professional competence in the law, shouldn't be swayed by partisan interests, public clamor, fear of criticism. Judge should hear and decide matters assigned and should maintain order and decorum in all proceedings before the judge. For example, we will look at that issue of maintaining order and decorum where we have a judge who steps off the bench to go search someone's home shortly. And a judge must be patient, dignified, respectful, and courteous to litigants. We're going to see several examples of that as we walk through these canons too. Now let's go to Canon 4, and Canon 4 on our next slide you can see here talks about how a judge may engage in extrajudicial activities, civic, charitable, education, religious, social, financial type activities, of course, and can speak and lecture on law-related and even non-law-related subjects. But what's the fencing principle here is that a judge shouldn't participate in these activities if it detracts from the dignity of the judge's office, interferes with the official duties, or reflects adversely on the judge's impartiality. So that line can be hazy at times, and the fundamental point I think that we can distill from this canon and several of them as they tie together like DNA helix strands is that a judge shouldn't engage in conduct that gives the impression that the judge may favor certain issues or people. And finally, we'll look at Canon 4, subsection G. With respect to chambers, resources, and staff, a judge should not, to any substantial degree, use judicial chambers, resources, or staff to engage in extrajudicial activities. So, let's get going with our Judges Gone Wild, and we're going to start with the case of the divorce court judge who decides to search and seize stuff from your home. It's true. This brings us to West Virginia in 2022, and this is the case of Gibson versus Judge Goldston. 21-181 is the case number. It's reported out of the District of West Virginia. July 13th, 2022 is the decision that I'm going to now tell you about. And so here are the basic facts. Husband and wife get divorced. There's a divorce property settlement, and they're supposed to divide up their things. You know, you get the dog, you get the CDs, you get the clothes, you get the paintings, whatever. But this is going on, apparently not working well. Who knew? Anyway, wife alleges contempt. So they go to a hearing, and at the hearing, the judge says, literally on the bench, I'll meet you all at the husband's house in 15 minutes. We're going to search the house and figure out what's going on with the property that's not being divided properly and where it is. So the judge literally walks off the bench, tells her bailiff, get down to the house. The husband, who's pro se, he goes down to the house. The wife and her lawyer, I guess, go down to the house too. Now the husband gets to the house and says, Judge, you're making yourself a witness. You got to disqualify yourself. The judge, on the spot, on his front lawn, denies the motion. The husband then says to the judge, well, I'm not allowing you to enter this house without a warrant. That's my home. Home is my castle. You don't have a warrant. You're not going in. To which our judge says, and this is a quote, oh, yes, I will. Let me in that house or the bailiff is going to arrest you for being in direct contempt of court. Now, at that point, of course, the husband had no choice, and so the judge entered the home along with the bailiff, and the police had been asked to come at this point. And now later on, the judge actually admitted to threatening the husband with this arrest if he refused to allow her and others into the home. So this isn't even made up. This is sort of an undisputed fact that you have quoted there. And the bailiff actually further testified in this subsequent lawsuit that came out of this melee that he witnessed the judge threaten the husband, whose name was Gibson, with arrest. And that as a sworn on-duty police officer, with arrest powers that the bailiff have, he would have been obliged to effect the arrest. In any event, the police arrive. Everyone starts rifling through the husband's home. The judge and the bailiff and the police go in, and they actually search the home for 20 to 30 minutes. And one of the facts that you just can't make this up is that the judge actually started hanging out in the recliner chair of the husband, just kind of chilling in his reclining, his big, lazy boy chair or whatever, and was just hanging out, holding court in his home, I guess, as the search went on. Now, the husband was obviously frustrated, as you can imagine, so he wanted to film the event on his cell phone. But the judge ordered him cease recording, and he was forced to surrender his cell phone. The bailiff, however, I think unbeknownst to the judge, it appears from the opinion, was recording everything. And so there's actually a video record of what was going on with our judge in the recliner. In any event, personal property was taken and no inventory was made. And the plaintiff, Gibson, then the husband, eventually alleged that some of this was never even returned, and that it was sort of bewildering ultimately to have a judge come in and execute a search warrant without probable cause from the bench just to figure out what's going on, and then not even bother to inventory what property is being taken when the whole case turned on an inventory of property itself. I mean, it's just utterly bewildering, obviously. And so this case goes before a federal district judge, and the federal district judge holds as follows. And the posing of the issue sort of answers it. And this is the quote from the case. Does a judge normally execute a search warrant or personally search a residence? To ask the question is pretty much to answer it. And that comes from page 9. And so what was held in this case is that when the husband sued the judge for an illegal warrantless search entry in violation of his federal civil rights, the judge had asserted judicial immunity, and the court said, oh no, you do not get judicial immunity. This is an illegal warrantless search in violation of the Fourth Amendment. It goes beyond all bounds in terms of transgressing questions of public confidence, integrity, impartiality in the case. So apparently, actually, when you read that case, this wasn't the only time this judge had done this. This judge apparently had made quite a habit of this in West Virginia, although I don't believe it's occurring anymore in West Virginia. So that's what happens. The lesson here, of course, for the judge is the ethics violations are myriad, blatant, and brutal. And I guess for the rest of us, if we're getting divorced, better be careful what you say to your judge. Now let's move to the judge who handcuffed the defendant's teenage daughter in court. Yes, you heard that right. This brings us from West Virginia all the way to the West Coast. And we're going to go to San Diego in 2023. And here we have a case where a federal district judge, Benitez, held a hearing. And this is a criminal case, and the criminal defendant was in court, and the hearing being held in this criminal case was whether the criminal defendant's bail needed to be revoked. Basically, the defendant had served his sentence, was then released from custody, but had supervised release, like probation terms and all that. And the defendant apparently violated his supervised release and probation terms and was potentially facing another jail term for this violation of the supervised release conditions. And so there's a hearing being held to address this, and the defendant was at the hearing, obviously, and the defendant's daughter, this 13, 14-year-old girl, was in court also. And the defendant actually told the judge and expressed some concern that his daughter was hanging out with people who might, quote, lead her down into the same path I went down, end quote. Now, why exactly the defendant was saying that, unclear. Perhaps the defendant was saying that I'm worried my daughter's hanging out with bad people. I don't want to go to jail. I got to be here to look after her. But for whatever reason, he says, I'm worried about my daughter. The judge then turns to the marshal and says, you got cuffs? The marshal, at the judge's direction then, believe it or not, cuffed this 13-year-old girl in the jury box. Now, the girl, as you can imagine, is 13 years old in a federal court watching her dad, who's been in jail, getting ready maybe to go back to jail. All of a sudden, she finds herself cuffed, put in the jury box. She starts crying, no surprise, and probably suffered significant trauma. And basically what happened is she was cuffed in there. The judge spoke to her for a while. And after allowing her to be released, the judge tells her that you're an awfully cute young lady, but that if you don't avoid drugs, you'd end up in cuffs and be right back there where I put you a minute ago, end quote. And that comes from the Reuters story that quoted what happened in this proceeding, which is now led to the Ninth Circuit opening a judicial misconduct case, number 2390037. This was in February 2023. The underlying criminal case was, of course, reassigned for this behavior by the judge. And a year after February 2023, we're into 2024, at least at the time of this filming, no ruling on that case, which seems pretty remarkable given the thin fact pattern and the pretty significant set of issues that occurred there. But that's what happens when you have multiple ethics canons really being tripped there by that kind of behavior. Now let's take a look at a case coming out of Alabama. We're going to shift back towards the East Coast, and we're going to look at the case of the judge who sent a woman to jail for a year. Yes, you heard it correctly, a year for unpaid parking tickets. This is 2016 in Alabama, and this is the case of In re Judge Lester Hayes. It's case number 49, and this is the final judgment from January of 2017. The basic facts are as follow. A single mother appears before the judge. She has lots of unpaid parking tickets and hasn't paid them, keeps getting tickets, doesn't pay them. And so the judge sentences this single mom to 496 days in jail. As a result of her being sent to jail, her children were literally sent to foster care. She's a single mother. And apparently other people, poor people obviously, who couldn't afford to pay their civil fines and tickets, were also routinely sentenced to jail time. So this ended up in an ethics inquiry before the Alabama, judicial, before the Alabama courts and the Alabama bar and the like. And what was found in this final judgment in case number 49 of that year, In re Lester Hayes, is that the judge was guilty of violating at least 10 different canons of ethics. Canon 1, 2, 2A, 3, 3A1, 3A3, 3A4, 3B1, 3B2. Massive, 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 massive violations for those ethics violations in terms of dropping people into prison for not paying parking tickets. The remedy? The judge was suspended without pay for 11 months. Can't make it up. Judge has gone wild. There you go. Now we're going to talk about the case of the judge who jailed a court spectator for dropping sunflower seeds in court. This starts shifting us back out west a bit. We're going to get to Oklahoma in 2015. And so here's the basic facts. And this is coming from 2015, where Judge DeLapp grew incensed when he learned that someone had dropped sunflower seeds in his courtroom. And after scouring the security footage, the video footage from a courtroom security camera, the judge actually figured out who the spectator was that had been dropping sunflower seeds in his court. And he later summoned that spectator, her name was Amanda Allred, to his chambers. He charged her with contempt and ordered her jailed for 4 days. Now, later on, we get to 2018, and this is after the spectator had been sentenced. He also sentenced for 6 months in jail someone for talking to her boyfriend during court. Now, you've now got the person being thrown into jail for some number of days for dropping sunflower seeds after the judge held a little investigation to figure out who it was and then, forced this person back to court from society to be sent to jail. And a few years later, then you've got the same judge, because a lady was in court talking to her boyfriend, and you're supposed to be quiet in court, we all know that, and she's whispering to her boyfriend and talking or whatever. The judge is very unhappy, orders her in jail for 6 months. At that point, basically, this judge, who was pretty well known in this area, but all the local lawyers were obviously very, very scared of this judge, local lawyers finally apparently found the courage to act, as it's reported. And basically what happened is lawyers filed a habeas petition. The Oklahoma Supreme Court almost immediately granted it to get the woman out of jail for talking. And what happened then is that a complaint was filed against the judge for multiple ethics canons violations, including both of those cases. Now, what happened here is, because the ethics charges were filed, the judge then simply chose to voluntarily resign, which allowed the judge to maintain his pension and his law license. And if you want to learn more about those cases and many of the other cases with this judge gone wild in Oklahoma, I have the links there for you. You can pull up these cases and look at them. They remind me actually of a story I had heard when I first started clerking in the 1990s in the Central District about a Central District judge who had, and this is a story, don't know if it's real, but it fits within Judges Gone Wild, so I'm going to share it with you. Apparently there was a judge, an old-timer judge, who in the 1960s, during sort of the, the height of the flower power peace movements, the hippies and all that, was sent out to Hawaii on designation to hear a case. And so you have this judge going out to Hawaii from California, conservative judge, and the judge has lawyers appear before him not wearing suits and with long hair, and apparently jailed one of them once that also required a habeas petition to get the lawyer out of jail. I guess the lesson there is take your toothbrush to court sometimes, because you never know what could happen. So let's move along. And now we're going to get to the case, and this comes out of the Seventh Circuit in Chicago. And this is the case of judges gone wild where they're actually taking bribes. And this brings us to Chicago in the 1970s. It's the case of United States versus Murphy. It's reported at 768 F. 2nd, 1518, 7th Circuit, 1985. And basically, the situation involves Cook County Judge Murphy. And Judge Murphy in Cook County had various judicial roles over the years. And the case, it's a very long case that walks through all of his different misdeeds. But we can start with Judge Murphy on traffic court. And while he was on traffic court, he took bribes to reduce DUIs or to dismiss cases. And basically what happened is the court deputy would deliver cash to the judge after the verdicts. And so the deputy was sort of the bagman, so to speak, who would get the lawyers get the money from the lawyers or the pro se people. He'd collect up the money and give it to the judge after the verdict. And so as an example, basically, we have, and this is one of the bribery cases, during trial, and this is a case where already the judge has been, offered a bribe to find a not guilty verdict. Nonetheless, in trial, the DA actually got the defendant to admit that her alcohol use did impact her and that she was intoxicated. Now, this is just almost too comical to make up, because you've got a situation here where you have a woman who has a lawyer. Apparently, the woman and the lawyer knew they were bribing the judge, and so she knew she was going to get off, and all she had to do was basically get up there and, I guess, lie. But nonetheless, the DA still got her to admit to her DUI. But the judge was being bribed. So what did the judge do? He ordered a recess. And when the case then resumed, the witness suddenly shifted her story and said, no, I wasn't drunk. The judge miraculously said reasonable doubt. Don't know. Case dismissed. DUI gone. Cash transferred. Now, in another case for our erstwhile judge, we have undercover informants who actually recorded the judge. And the quote from the opinion is as follows. The lawyer conceded that his client was guilty, but said he needed a verdict of not guilty. The judge said, "It'll be discharged, that's all." And he later acquitted the defendant. Now, this is an example of a case of a judge who's gone way too far, obviously. And this led to bribery, RICO, extortion, all manner of charges being brought, for which the judge lost, and the judge here was jailed. And so this is an example when we talked about remedies, and we've seen some remedies already of censure, judges stepping down to avoid sort of horrendous punishments. Other judges getting what looked like light slaps on the wrist. Here we have a judge gone wild and gone to jail. Let's take a look now at the case of the judge who goes on vacation with the prosecutor at the end of the trial. And you remember from the beginning our ethics canons about avoiding even the appearance of impropriety and not having enmeshed personal relationships that could question whether you are able to remain impartial. Those canons are at play in this case, and this is the case of United States versus Murphy. It's reported at 768 F. 2nd, 1518. It's also coming out of the Seventh Circuit in 1985. For those of you in the Seventh Circuit, I'm not picking on you. We have these cases all over the country. It just so happens it's a useful case to look at. So basically what we have is the Judge Koukouras, again, confronting his own ethics dilemma. And this is sort of, it's hard to even make sense of what's going on here because this is the case, as you know, of the judge who went to jail for bribery. And now we have the judge in the case of the judge who went to jail for bribery, the judge himself facing his own ethics questions. And so it's sort of, I had to use this case because you just can't make it up, right? The defendant judge is going to jail, and the judge overseeing the case of the defendant judge himself trips into an ethical dilemma. And so here's the ethical dilemma. We have Judge Murphy going to jail in the case, and we have Judge Koukouras being the federal district judge proceeding over the case. And it turns out that Judge Koukouras was a close friend of the prosecutor, the federal prosecutor who was trying to put Judge Murphy in jail. And indeed, apparently they were the best of friends. I mean, you know, these were good friends, the prosecutor and the judge. And Judge Murphy's long RICO bribery case goes through the process, and you know, he then gets sentenced by Judge Koukouras. And what happens is immediately after our corrupt judge defendant is sentenced, Judge Koukouras goes on vacation with the prosecutor, like literally the next day, apparently. Basically, the sentencing hearing was actually advanced to be done so that this group vacation, you know, Judge Koukouras and his wife and kids, the prosecutor, his wife and kids are all going to go off on a little vacation. They had their vacation planned, but the sentencing of Judge Murphy was in the way, so they decided we got to advance the sentencing. Let's get him sent off to jail so we can go on vacation. And they did all that. So in any event, this makes its way up to the Seventh Circuit. And the Seventh Circuit found that this level of friendship was unusual. And the objective test under 28 U.S.C. 455, that question we raised about the appearance of impartiality, did indeed require disqualification, that Judge Koukouras should have disqualified himself. And basically, the governing rule of law and coming out of the case is that, quoted here from page 1538, most people would be greatly surprised to learn that the judge and the prosecutor in a trial of political corruption had secret plans to take a joint vacation immediately after the trial. An objective observer might wonder whether the judge could decide the case with the requisite aloofness and disinterest. You just can't make it up, right? I mean, this is sort of, we have judges gone wild when presiding over cases of other judges gone wild. I mean, it's just sort of everyone's off the playing field here. And what ultimately happened, though, oddly enough, is that Judge Koukouras actually avoided disqualification ultimately because the defense knew about what was going on and waited too long to file their motion. And as it turned out, apparently, the defense lawyer was also hanging out with the judge at social events, and they were all a gaggle of friends. But from this, we should not take the lesson that it's okay the Seventh Circuit did find this to be deeply unusual and deeply improper substantively, even if there were procedural hooks for our judge to get out of it. Now we're going to look, and we talked about canons earlier, about judges being involved in issues of public controversy or public commentary, and then addressing them and dealing with them when those cases come before the judge. And this brings us on our slide here to Kansas in the 1990s. And we're going to be looking at the situation of judges engaged in public commentary on issues and then addressing cases on those very same issues. And this brings us to the case of United States versus Cooley. It's reported at 1F 3rd 985, and you can get to the core of it if you go read page 995, what our holding. But nonetheless, this comes out of the 10th Circuit in 1993. And so here are the basic facts. It's early 1990s. Abortion protests on all sides of the abortion debate are going on across America, of course. And some of the protesters who were against abortion would block access to medical clinics. And basically what happened is you had a whole bunch of people engaged in sort of this behavior of illegally blocking other people's right to access medical clinics. And so what happened is various people who were engaged in this sort of business of blocking access to clinics were ultimately arrested and indicted. And they had these cases and get assigned to a judge, Judge Kelly. Now, what had Judge Kelly already been doing? Well, it turned out that in this place in Kansas where these abortion protests were occurring, it actually was sort of ground zero almost for this big public controversy at the time, and the right to block, the right to have an abortion, and all those fights that were going on. And this had been going on for a while here, and it had attracted national attention. In fact, so much national attention that Barbara Walters showed up with her television cameras and TV show to do a program about the protests, and lo and behold, Barbara Walters interviewed Judge Kelly. And what Judge Kelly said to Barbara Walters, and this, of course, is before the arrests and the cases were sent to Judge Kelly, but Judge Kelly gets on TV with Barbara Walters and says, "These people are breaking the law." That's a quote. And the Judge Kelly had also been quoted in national media saying, "If anyone plans to come to Wichita, they'd better bring a toothbrush." That's a scary comment. I've often wondered when I go to court if I need to bring a toothbrush, but this judge actually is telling you, you better bring a toothbrush. So what happened? Judge gets interviewed, he's on TV. Clearly Judge Kelly's got opinions about this and has opined on the actual behavior of people in terms of what they're doing, concluded that these people are breaking the law. Judge Kelly then gets assigned the cases when the people get arrested for this behavior. Judge Kelly is asked to disqualify himself. He refuses to let go of the case, however, and then sentences the defendants. So, the ethics question. Well, here's what the 10th Circuit held. Together, these messages unmistakably conveyed an uncommon interest and degree of personal involvement in the subject matter. It was an unusual thing for a judge to do, and it unavoidably created the appearance that the judge had become an active participant in bringing law and order to bear on the protesters, rather than remaining as a detached adjudicator. So, disqualification should have occurred, and the convictions were vacated. And so there you see the significant consequences, not just for the judge who tripped those ethics rules and was held to have violated the rules and then should have been disqualified. Nothing in the record of that case, at least, explains what happened to the judge. I mean, the judge didn't lose the federal judgeship, lose salary, or anything like that. But the judge did cause those convictions to get vacated, which means, you've had a whole set of people attending trial, and juries, and witnesses, and prosecutors, and defense lawyers, and all that stuff was just a big waste, right? So the convictions were vacated as a result. And so this is an example of the canon we looked at earlier, where judges need to maintain some level of distance from public issues, or if they do want to be interviewed by Barbara Walters and talk about this is all illegal and terrible what people are doing, they're going to have to recuse themselves from appearing in those cases. Now we're going to shift to the 5th Circuit, and on our slide here you can see we're going to look at issues of judges gone wild dealing with improper race comments. And this case brings us to Houston, Texas in 1997. And the case is In Re Chevron USA, Inc. It's reported at 121 F 3rd 163. And if you want to get into the heart of the comments of the judge, you kind of have to dig into the case's footnotes. I don't think the panel that ultimately wrote the opinion here wanted to sort of publish them too prominently, so they're buried in footnote 12 in tiny font on pages 166 to 167 of the Federal Reporter. But it's a Fifth Circuit decision from 1994. And so basically, here's the facts of what's going on in the Chevron lawsuit. It's a mass tort claim by a predominantly black neighborhood against Chevron. And the African-American judge made sarcastic comments about the race of the experts being Caucasian and rejected an expert study being offered by that expert. Now, the plaintiff and the judge both claimed that this was sarcastic, and the court seemed to accept the fact that it may well have been sarcastic. But nonetheless, the underlying issue of the case was that there was a mass tort that had been done by Chevron to what is a predominantly black community, and now you have the judge commenting on the race of the experts being Caucasian and rejecting the reports. And so here are the actual comments that you can get from the judge at that footnote 12. Quote, and the judge was an equal opportunity offender, as you're going to see. It wasn't just white and black. Quote, why do you think Chinese people are short? Because there is so damn much wind over there that they need to be short. Why are they so tall in Africa? Because they need to be tall. It's environmental. I mean, you don't jump up and get a banana off the tree if you're only 4 feet. If you're 7 foot tall and you're standing in China, then you're going to get blown away when that Siberian wind comes through, end quote. You can't even make this stuff up, but I put it in quotes because I cut and pasted out of the opinion, because that's what he said. Then we can see the next quote. Those comments were followed by a reference to the ultimate wisdom of the deity and these remarks. I think he knew that people in China didn't need to be tall and that people in Africa did. I think he knew that people in Africa needed to have this stuff in their skin because if they didn't, they wouldn't have survived in the jungle. I think he knew that the people in Europe, Great Britain, didn't need it because if they had that stuff in their skin, they would have died. But because they don't have that pigmentation, they can live in Europe. Because I have the pigmentation, I can't live in Europe. So these are the comments of the judge. And let's go to our next slide here on In Re Chevron 121 F 3rd 163. And this is the holding at page 166 to 167 on our improper race comments. This is what the court held. We perforce agree with Chevron that the challenge statements and comments are unfortunate, grossly inappropriate, and deserving of close and careful scrutiny and most serious consideration. It is totally unacceptable for a federal judge, irrespective of the judge's color, to make racially insensitive statements or even casual comments of the same during the course of judicial proceedings. Such are not to be tolerated in any litigation and most decidedly are verboten in litigation in which racial or ethnic considerations are relevant to the issue before the court. When they occur, the risk of creating a public perception that the judge has a bias or prejudice which might affect the outcome crosses the prescribed threshold. This is especially true in a racially charged case, such as the instant one. Accordingly, here a reasonable person might indeed harbor doubts about the trial judge's impartiality, and recusal would be appropriate under the terms of Section 455A. And so there you see an example of these improper race comments triggering the need to disqualify for the ethics, codified ethics rules at Section 455, which track, of course, the canons of ethics that judges are obligated to be bound by. And this is an example of a case where we have the importation of race in myriad respects in terms of it being grossly improper. And that comes out of the Fifth Circuit in 94. We're going to pivot from the Fifth Circuit in 1994 to our second example of improper race statements. And this is our next slide, improper race statements number 2, which brings us to the 10th Circuit. And we're going to go to Topeka, Kansas, 2006. This case is the case of United States versus Franco Guillen. It's reported at 196 Federal Appendix 716, and it comes out of the 10th Circuit in 2006. And the basic facts are as follows. You have a guilty plea in a criminal case by a Hispanic defendant. And he enters this plea colloquy with the court where he agrees that no promise of a sentence has been made to him in return for his guilty plea. He goes through this plea colloquy with the court to make sure it's voluntarily knowingly made, it's voluntary, it's intelligent, there's been no quid pro quo and all that, and the court then accepts his guilty plea. Now, sometime later, he gets sentenced, and he files a motion to change his plea because he thought he had an agreement to a 12 to 15-month sentence, and he didn't like the sentence he got. So he files this motion to change the plea. Here is the quote from the judge when the judge gets this motion to change the plea on the basis that he didn't understand the original plea deal he had made. The judge says, quote, "I will not put up with this from these Hispanics or anybody else, any other defendants. I've got another case involving a Hispanic defendant who came in here and told me that he understood what was going on and that everything was fine. And now I've got a 2255 from him saying he can't speak English." Footnote, 2255 is the federal habeas petition, where that other client was apparently coming in making a similar claim to this defendant. And let's go on with what the judge said. "And let me tell you this, sir. You've got a long prison record, and you've got more aliases than I've seen anybody have except one individual down in Las Cruces, New Mexico. And you are facing 20 years if you're convicted by a jury. When can this case be ready for trial?" The prosecutor responds, "Just within a matter of 10 days or less, Your Honor." The judge says, "Set the case. We'll notify you when it's ready. Nobody can come in here and lie to me and get away with it," end quote. So the attempt to withdraw the plea led to these brutal comments from the court, including this sort of framing of this sort of this race-based commentary about the defendant's Hispanic race. And so here's what the 10th Circuit held when it got this case. The judge's statements on the record would cause a reasonable person to harbor doubts about his impartiality, without regard to whether the judge actually harbored bias against Franco Guillen on account of his Hispanic heritage. The judge was ordered disqualified. And so there again, we have an example of, federal appellate courts taking very seriously ethics issues when they start intersecting with race. And that we've seen it both in the 5th Circuit and the 10th Circuit. And again, not picking on either the 5th or the 10th. You can get them in all circuits. Now we're going to go back in time a little bit to our Judge Landis. And you remember our picture of Judge Landis? He looked kind of scary. I mean, honestly, if I had to go before Judge Landis, I'd be scared. The guy looked very serious in that picture. And it turns out that Judge Landis made his way into the annals of jurisprudence all the way up to the Supreme Court for some other behavior of his. This brings us to Chicago in 1918. And this is the case of Berger versus United States. It's reported at 255 U.S. 22 from 1921. And here our judge gone wild is anti-German hatred. Yep, you heard it right. So let's talk about it, the facts. It's World War I, and there's an espionage case being brought against German Americans for ostensibly helping the German war effort. And of course, the Germans were our enemies in World War I. And so these defendants end up finding themselves in their criminal case before Judge Landis. Don't know if he was tied up doing his baseball work at this point or not, but he was still a district judge. And so here is what Judge Landis actually said on the record, and these are quotes, again, that I took from the Berger v. U.S. opinion from the Supreme Court. Quote, this is what Judge Landis said, quote, "One must have a very judicial mind indeed, not to be prejudiced against the German Americans, because, quote, their hearts are reeking with disloyalty." Another quote, "If anybody has said anything worse about the Germans than I have, I would like to know it so I can use it," end quote. I know you're all scratching your head saying, "I can't believe it. You can't make it up." Yes, it's true. They're in the opinion. And the third quote, "You are of the same mind that practically all the German Americans are in this country, and you call yourselves German Americans. Your hearts are reeking with disloyalty. I know a safe blower. He's a friend of mine who is making a good soldier in France. He was a bank robber for 9 years. That was his business in peacetime, and now he is a good soldier. And as between him and this defendant, I prefer the safe blower," end quote. So in any event, you can imagine a judge who feels that way about Germans in a case involving German Americans and espionage, didn't go well. And so this case made its way up to the U.S. Supreme Court that ultimately held that the prejudice involved here by the judge was so profound that the judge simply should have recused himself from hearing the case of Berger versus United States. Luckily, none of us have to appear before Judge Landis. Let's now go to our remedies slide you can see here. And here we have a few cases I'm going to give you. And really, the title of this slide is Just Can't Make It Up, because it really is a type of stuff you just can't make it up. It's all real. So we're going to start with the first case from Utah. In re Judge Dow. And this case number is 193JC-012. This comes out of Utah, September 13th, 2019. And what I've actually done for you here is I have linked in your materials the actual decisions. So you can go read them so that you don't just take my word for it, because these judges have gone wild. So let's look at what happened with Judge Dow. This case in Utah involved a judge who texted a photo of a man's scrotum to his court clerks. Yes, that is correct. That's what he did. The remedy? He was reprimanded. I think the rest of us may go to jail. We'd probably be disbarred. This judge got reprimanded. That was Utah, 2019. Now let's go to Texas, 2019. This is the case of in re Judge Robison, case number 18-0510. It's Texas, February the 20th, 2019 decision. Here, our Judge Robison entered the jury deliberations while the jury was deliberating. And what the judge told the jury was that God had come to the judge and told him that this man should not be convicted. Now, this case ended with the ethics conclusion of a public warning. The judge fell on the sword and apparently immediately recognized that he should not have told the jury that the judge had been told by God that the man should not be convicted, and he shouldn't have shared those conversations he had with God with the jury. And he accepted responsibility immediately, and it resulted in a public warning about the judge. You don't say. The next case is in re Judges Adams, Jacobs, and Bell, and this comes from the Indiana Supreme Court in 2019. And yes, the title involves 3 judges, because here we have 3 judges who were hanging out, having a good time, drinking in public. Tried to go to a strip club, but it was closed. So I guess they were hungry and they went down to White Castle to grab some White Castle burgers. Now, they end up getting into a verbal and a physical fight with one person named Kaiser. Kaiser, I guess, was someone who just showed up there and they all didn't get along and whatever. And so the 3 judges and Kaiser end up getting into this verbal physical fight. One of the judges actually kicked Kaiser in the back. Kaiser, believe it or not, pulled out a gun and shot 2 of the judges. This led to judicial misconduct findings when the judges were hauled before the Indiana Supreme Court. And they were found to have engaged in misconduct, and they received suspensions ranging from 30 to 60 days. And our last little case here, looking at remedies, we've kind of worked our way up from reprimands, public warnings, to suspensions, getting to some more serious remedies on this one. This is the case of in re Judge Thompson. It's reported at 194 P3rd 1281. It's coming from Oklahoma in 2008. Here we have a judge who used a sex gadget penis pump while on the bench, in trial apparently, and exposed himself to others while using this sexual gadget. This judge, in turn, was disbarred, and it also led to a criminal conviction for the use of the sex gadget and the exposing of oneself to others. And there you have the links to go read the decisions, so you can see it's all real. Judge has gone wild. We're not making it up. Now we're going to shift to Orange County, California, my backyard. The judge who had sex in his chambers with a former intern. In re Judge Steiner, and here are the facts. The judge had sex with 2 women in his chambers. Now, each had been former law students of his when he taught. One was a former intern of his, and the other a lawyer in the courts. The judge, I don't believe, was having sex with them while they were law students. It was just while one was a former intern of his and the other a lawyer in the courts. And the law-student relationship was just where they first knew each other. The judge did a letter of recommendation for one of them to help her get a job in the DA's office, and she was not hired. And so he called up the DA perplexed as to why his letter had been ignored and why she hadn't been hired. And here is what the court held in re Judge Steiner. Judge Steiner's conduct in initiating contact with the district attorney's office about the employment application of Ms. A at around the time he was engaged in a sexual relationship with Ms. A, in order to follow up on her letter of recommendation he had sent on Ms. A's behalf, asking questions about the interview and hiring process and expressing irritation that his recommendation had not resulted in her hiring, exceeded the scope of conduct permitted by Canon 2B. That was the ethics transgression there in terms of the pushing to get this person hired based on his letter when he was engaged in a sexual relationship with her. Now, as to the other lawyer, number 2, the one he had sex with and had cases before him, he did recuse himself, but he then reassigned those cases of the lawyer he was having sexual relations with before him. He reassigned her cases to particular chosen judges. He just sort of took the case and assigned it to Judge A, B, C, or D. Now, this was held improper because a disqualified judge simply cannot pick the next judge. Quote, this was contrary to Canon 2A, which requires judges to respect and comply with the law and act at all times in a manner that promotes public confidence in the integrity and impartiality of the judiciary. That's Canon 3B, which requires judges to be faithful to the law, and Canon 3E, which requires judges to disqualify themselves in any proceeding in which disqualification is required. Basically, you don't get to pick the next judge. You get hands off and let the case get randomly reassigned. The punishment here, public censure. And the people in my backyard re-elected our judge. Now let's go to the case of the judge trading verdicts for sex. And this is in re Judge Gravely. Yes, you heard it. South Carolina, 1996. Pro se woman shows up at an eviction hearing. The judge ruled against her. After the hearing, the judge suggested, come back to my chambers later. There could be a way for us to work out the situation. So she returns later the afternoon to the judge's chambers. No one else is there. She and the judge proceeded to have sex in the judge's chambers. Now, the woman later explained that she did it because the judge told her it could keep her in her home. She was unemployed, had no money, had 2 small children, was a single mother, and she felt she had nowhere to go if she was evicted. This case made its way up to the South Carolina courts. You've got the case site up there, and here the court held the judge has failed to maintain, enforce, or observe high standards of conduct to ensure that the integrity and independence of the judiciary are preserved. Public reprimand is the most severe sanction that can be imposed because the judge resigned. And so what happened here is the judge simply resigned, no longer held office, and so the most that they could do was issue a severe public reprimand for apparently trading verdicts for sex, offering to help someone not be evicted. Our final case of Judges Gone Wild today involves the judge, the public defenders, and the hot tub. And this takes us to Las Vegas in 2022. All right, so here's the case. And there you've got a quote of the 3 canons from the actual judicial complaint that was filed against Judge Bayou. And this is the case of in re Judge Bayou. Judge Bayou posted a photograph of her Facebook page of herself in a hot tub with 2 public defenders with the caption, Robson is surrounded by great TITS. And I spell it out for you, but her, as you can see the screenshot from Exhibit B from the complaint there, didn't spell it out. You got the judge and 2 public defenders hanging out in a hot tub. And apparently the judge saying that Robson, the guy in the middle, is surrounded by some great TITS. In any event, this is now pending in Las Vegas, and there are multiple canons that the judge has been charged with in terms of improper behavior, and this kind of brings us to the end of our program in terms of a reminder of those canons. Acted at all time and manner that promotes public confidence in the independence, integrity, and impartiality. Don't convey the impression that any person or organization is in a position to influence the judge. When engaging in extrajudicial activities, a judge shall not participate in activities that would appear to a reasonable person to undermine the judge's independence, integrity, or impartiality. Stay tuned for Judges Gone Wild Part 2. We'll let you know in the next series of this what the punishment was. Our conclusions as we end this program today then are that, in all seriousness, the ethics rules are read with significant import facially. I mean, we have all these canons that are very, very significant and serious in terms of what they say, in terms of what we expect of our judges to not cross these ethical lines. And they're significant because as we went back just 100 years, they didn't even exist. And we saw Judge Landis and what he got away with doing. And so these basic canons that we need to keep in mind and remember as judges, as lawyers appearing before judges, critically involve a few that sort of intersected with the different cases we saw today. To act at all times in manners that promotes public confidence in the integrity and impartiality of the judiciary, avoid even the appearance of impropriety, perform duties with respect for others, don't engage in behavior that's harassing, abusive, prejudicial, or biased. And ultimately, a judge shouldn't use any substantial degree of chamber resources or staff to engage in these extrajudicial activities at all. So we saw myriad circumstances of violations of our judges gone wild. And we saw, frankly, that the remedies are varied, remarkably varied. And there's a really broad range from what seem like very light punishments for a lot of this conduct, but which all the way does lead up to disqualification, voluntary retirement, and even jail we saw for our bribing judge. There you have it. Check back for our other programs. Thank you very much.